I request everyone to kindly take their seats, please. May I request everyone to settle down, please? May I request everyone to please take their seats? The members of the organizing committee and the volunteers are requested to please help the guests. I request everyone to please take their seats. Thank you for your patience. We will be commencing shortly. May I request everyone to please take their seats? We welcome our chief guest for the day, Honorable Mr. Justice Surya Kant, Judge, Supreme Court of India. Good morning, distinguished dignitaries, honored guests, ladies and gentlemen. It is my profound privilege to welcome you all to this closing session of the Delhi Arbitration Weekend 2025. Gracing the occasion today, we have amongst us in the audience Honorable Mr. Justice Surya, Judge, Supreme Court of India, Mr. Gary Bond, Honorable Mr. Justice Devendra Kumar Upadhyay, Chief Justice of the Delhi High Court, Honorable Judges, Senior Advocates, the Law Secretary, and other honorable dignitaries. Please put your hands together for our esteemed guests. Over the past days, we have shared ideas, debated perspectives, and strengthened our collective resolve to advance arbitration in India and beyond. Today's session brings together some of the most respected voices in law, academia, and policy. Individuals whose leadership has shaped the global discourse on arbitration and whose insights will continue to guide us into the future. Before we begin with the addresses from our distinguished speakers, we take a moment to celebrate the rich cultural heritage of India. It is our honor to present a special performance by Padma Shri Pandit MADHUP MUDCAL, an acclaimed Hindustani classical vocalist whose artistry has enthralled audiences across the globe. We also have the artists accompanying MUDCAL. On tabla, we have Shubhunath Bhattacharya and Khadak Singh ji, Manish Sharma ji on the harmonium, Anurod Jain ji on manjira and percussion, Swati Mudgal, Vivek Bhola and Kushal Sharma ji on vocal support and tanpura. Please put your hands together for Pandit Mudgal ji and all the artists.
सहज बेली जब फूलन ला पंजर जाई बाणी पिलम्ब्या सतगुरु बाई बेली बेली मन पंजर जाई बाणी पिलम्ब्या सतगुरु बाई बेली बेली पंच सखी मिली पवन परम प्यार पंच सखी मिली पवन परम प्यार बाड़ी पाड़ी मिली ये राम गुण में लड़ी रे राम गुण में लड़ी रे अवधूत गोरखनाथी जानी गोरखनाथी जानी गोरखनाथी जानी गोरखनाथी जानी काटत बेरी कुपल मेरी सींच ताड़ी कुमिलाणी कुमिलाणी काटत बेरी कुपल मेरी सींच ताड़ी कुमिलाणी कुमिलाणी कह कबीर ते बिरला जोगी कह कबीर ते बिरला जोगी सहज निरंतर जानिए राम गुण बेलड़ी रे राम गुण बेलड़ी रे अवधूत गोरखनाथी जानी गोरखनाथी जानी गोरखनाथी जानी गोरखनाथी जानी नाथी स्वरूप ना छाया जात बिरध कर बिन पाणी राम गुण में लड़ी रे राम गुण में लड़ी रे अवधूत गोरखनाथी जानी गोरखनाथी जानी गोरखनाथी जानी गोरखनाथी जानी आँखि मध्य द्वारा आँखि मध्य द्वारा यही द्वार दूरबीन लगा कर यही द्वार दूरबीन लगा कर उतर भव जल पारा उतर भव जल पारा मुर्शिद नैनो बिचनवी है मुर्शिद नैनो बिचनवी है सुंदर सहरण बास हमारा मोहे सुनी सुनी मोहे सुनी सुनी आवे मोहे सुनी सुनी मोहे सुनी सुनी आवे हंसी मोहे सुनी सुनी आवे हंसी मोहे सुनी सुनी आवे हंसी रे पानी में मीन यासी मोहे सुनी सुनी किनारे माही कस्तूरी, मृग किनारे माही कस्तूरी, बन बन खोजत बासी, पानी में मीन पियासी, पानी में मीन पियासी, मोहे सुनी सुनी आवे आसी रे, पानी में मीन पियासी, पानी में मीन पियासी, पानी में मीन पियासी। आत्मज्ञान बिना सब झूठा, क्या काबा क्या काशी, आत्मज्ञान बिना सब झूठा, क्या काबा क्या काशी, गंगा जाए गोदावरी के लिए, गंगा जाए गोदावरी के लिए, भगति बिना सब नासी, पानी में मीन पियासी, पानी में मीन पियासी, मोर सुनी सुनी आवे आसी रे, पानी में मीन पियासी, पानी में मीन पियासी, पानी में मीन पियासी। जल थल सागर पूर रहा है, भटकत फिरे उदासी, जल थल सागर पूर रहा है, भटकत फिरे उदासी, कहे कबीर सुनो भाई साधो, कहे कबीर सुनो भाई साधो, सहज मेरे अविनाशी, पानी में मीन पियासी, पानी में मीन पियासी, मोर सुनी सुनी आवे आसी रे, पानी में मीन पियासी, पानी में मीन पियासी, पानी में मीन पियासी, पानी में मीन पियासी, मोहे सुनी सुनी। जरा हल्के जरा हल्के गाड़ी हाँकियो, जरा हल्के गाड़ी हाँकियो, हाँकियो हाँकियो, जरा हल्के गाड़ी हाँकियो, मेरे राम गाड़ी वाले, जरा हल्के गाड़ी हाँकियो, मेरे राम गाड़ी वाले, जरा हल्के गाड़ी हाँकियो। राम गाड़ी वाले जरा
हल्के गाड़ी हाकियो मेरे राम गाड़ी वाले जरा हल्के गाड़ी हाकियो मेरे राम गाड़ी वाले
जरा धीरे गाड़ी हाकियो जरा धीरे गाड़ी हाकियो मेरे राम गाड़ी वाले जरा हल्के गाड़ी हाकियो मेरे राम गाड़ी वाले
जरा हल्के गाड़ी हाकियो मेरे राम गाड़ी वाले
गाड़ी हमारी रंग रंगीली पहिया है लाल गुलाबी गाड़ी हमारी रंग रंगीली पहिया है लाल गुलाबी आकड़ वाले चल छबीले आकड़ वाले चल छबीले बैठण वाला राम जरा
हल्के गाड़ी हाकियो
मेरे राम गाड़ी वाले
जरा हल्के गाड़ी हाकियो मेरे राम गाड़ी वाले
चार जना मिल हाथ उठाया बांधी काट की घोड़े
चार जना मेरे हाथ उठाया बांधी काठ की घोड़ी
ले जाकर मरघट पर फूकी ले जाकर मरघट पर फूकी फूक दीनी जस बोली
जरा हल्के गाड़ी हाकियो मेरे राम गाड़ी वाले जरा हल्के गाड़ी हाकियो मेरे राम गाड़ी वाले
मेरे राम गाड़ी वाले मेरे राम गाड़ी वाले बिलख बिलख कर तिरिया रोए बिछुड़ गई मेरी जोड़े
बिलख बिलख कर तेरी रोए बिछुड़ गई मेरी जोड़ी
कह कबीर सुनो भाई साधो कह कबीर सुनो भाई साधो जिन जोड़ी तिन तोड़ी
जरा हल्के गाड़ी हाकियो
मेरे राम गाड़ी वाले
जरा हल्के गाड़ी हाकियो मेरे राम गाड़ी वाले
मेरे राम गाड़ी वाले मेरे राम गाड़ी वाले जरा
हल्के
गाड़ी हाकियो मेरे राम गाड़ी वाले जरा हल्के गाड़ी हाकियो मेरे राम गाड़ी वाले ऐसा ध्यान 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 धरो नर मरे सबद वनाभद चिंतन करी ऐसा ध्यान धरो नर मरे सबद वनाभद चिंतन करी ऐसा ध्यान 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 ऐसा ध्यान धरो नर हरे सबद वनाभद चिंतन करिए पहले खोजो पंच भाई व्यंदल लगन समाय
पहिले खोजो पंच भाई व्यंदल लगन समाय
गगन ज्योति का त्रिकुटी संगी रवि शशि पवन मेलो बंदी ऐसा ध्यान धरो नर हरे सबद वनाभद चिंतन करे
ऐसा ध्यान धरो नर हरि सबद वनाभद चिंतन करी
मन थिर होत कवल प्रकाश कमला माई निरंजन पास मन फिर होत कवल प्रकाश कमला माई निरंजन पास सतगुरु संपट खोली दिखाव निगुरा होय तो कहाँ बताव ऐसा ध्यान धरो नर हरे सबद वनाभद चिंतन करी
ऐसा ध्यान धरो नर हरि सबद वनाभद चिंतन करी
सहज लक्ष्मण तजो पाधि आसन दृढ़ नेत्रा पुनि साधि सहज लक्ष्मण तजो पाधि आसन दृढ़ नेत्रा पुनि साधि कुहप पत्र जहाँ हीरामणि कह कबीर दास त्रिभुवन धनी ऐसा ध्यान धरो नर हरे सबद वनाभद चिंतन करी ऐसा ध्यान धरो नर हरे सबद वनाभद चिंतन करी सहज लक्ष्मण तजो पाधि आसन दृढ़ नेत्रा पुनि साधि सहज लक्ष्मण तजो पाधि आसन दृढ़ नेत्रा पुनि साधि कुहप पत्र जहाँ हीरामणि कह कबीर दास त्रिभुवन घनी ऐसा ध्यान धरो नर हरे सबद वनाभद चिंतन करी ऐसा ध्यान धरो नर हरे सबद वनाभद चिंतन Again.
the Honorable Minister of State, Ministry of Law and Justice. Please welcome him with a warm round of applause. Now we turn to thank Pandit MADHUP MUDCAL ji and the artists for such a moving and soulful performance. Before we proceed further, it is our honor to present Pandit MUDCAL ji with a citation of honor. I take this opportunity to read out the citation to the audience. In recognition of his distinguished contribution to the Indian classical music and his lifelong dedication as a vocalist, composer, and guru, Pandit MADHUP MUDCAL is celebrated as one of the foremost custodians of Hindustani classical tradition. Honored with the Padma Shri, Pandit MADHUP MUDCAL ji is revered for music that embodies depth, purity, and spiritual resonance. As principal of Gandharva Mahavidyalaya, he has nurtured generations of students, ensuring the continued vitality of India's musical heritage. On the occasion of the Delhi Arbitration Weekend 2025, the Supreme Court of India, the High Court of Delhi, and the Delhi International Arbitration Center are privileged to honor Pandit MADHUP MUDCAL ji for his timeless dedication to Hindustani classical music, his role in preserving India's rich cultural traditions, and his performance at the closing session of DAW 2025. His recital this evening has brought serenity and inspiration to the gathering, leaving a memorable close to DAW 2025. We extend our heartfelt gratitude for his artistry, generosity, and presence. I now request the Honorable Chief Justice of the Delhi High Court, Honorable Mr. Justice Devendra Kumar Upadhyay, to felicitate Pandit MADHUP MUDCAL ji by presenting a shawl, pattam, and the citation of honor. Please put your hands together for Pandit ji. I request the Honorable Chief Justice to also felicitate all the artists by presenting a shawl and memento. May we request Pandit ji and all the artists to be present for a group photo? We thank Pandit MADHUP Mudgalji and all the artists for their valuable time and the performance once again. Thank you. Thank you, everyone. We will commence with the closing session shortly. I request you to please remain seated. Inspired and spirits uplifted, we now turn to the core of today's session, hearing reflections from some of the most distinguished voices in the world of law and arbitration. I now invite our esteemed guests, Honorable Mr. Justice Surya Kant, Judge, Supreme Court of India, Shri Arjun Ram Meghwal ji, Honorable Minister of State, Ministry of Law and Justice, Mr. Gary Bond, Chair of the International Arbitration Practice Group at Wilmer, Cutler, Pickering, Hale and Dorr LLP, Honorable Mr. Justice Devendra Kumar Upadhyay, Chief Justice of the Delhi High Court, and Honorable Mr. Justice Subramaniam Prasad, Judge, High Court of Delhi, and Chairperson of the Organising Committee, to join us on stage, please. Please give a huge round of applause. Ladies and gentlemen, as we gather for the closing session, it is fitting that we end the weekend with a voice that has helped shape the very field we are here to celebrate. It is my privilege to introduce Mr. Gary Bond, a name synonymous with international arbitration. Mr. Bond is the chair of the International Arbitration Practice Group at Wilmer, Cutler, Pickering, Hale and Dorr LLP, and is widely recognized as the world's leading authority on international commercial arbitration, investment arbitration, and international litigation. His treatise, International Commercial Arbitration, referred popularly as the Bible of Arbitration, is considered the preeminent work in the field and has shaped practice and scholarship across jurisdictions. Over the course of his career, Mr. Bond has acted as a counsel in more than 675 arbitrations, including several of the most significant arbitration of recent decades, and has served as an arbitrator in more than 200 cases. His contributions go beyond practice. He has also played a defining role in developing arbitral jurisprudence, mentoring practitioners, and fostering a global culture of arbitration. It is not often that we get to hear from someone who has so fundamentally influenced both the theory and practice of international arbitration. Please join me in welcoming Mr. Gary Bond to deliver the keynote address on the theme International Arbitration, Past, Present, and Future.
Thank you, distinguished guests, colleagues, and friends. Thanks in particular to the Delhi International Arbitration Center, the Delhi High Court, the Supreme Court of India for inviting me here. Perhaps most of all, though, thanks to each one of you for, on a beautiful day here in Delhi, choosing to spend your time listening to me instead of being out in beautiful sunshine when the rains have left. Thank you for having me, and it's an honor and a privilege. I'd also like to, by way of introduction, apologize. I don't have a paper. I don't even have any notes, so I won't be able to read you that. But I do have pictures, and as we know, a picture tells 1,000 words. And so what I'd like to do today is take a step back. We usually look as advocates, as judges, at keyhole issues, precise technical questions. This isn't a keyhole lecture, it's a keynote. And I'd like to take a step back and think about with you what international arbitration is, where it's been in the past, where it is today, and as we can see from the picture, where it will go in the future, especially here in India. I'd like to describe first the slides very briefly, which we're going to look at together. On the left is a picture which is especially appropriate in this venue, this room, this court today. It's the mural in the main courtroom in the Peace Palace, the seat of the International Court of Justice, and it's titled Peace and Justice. It's titled, as you can probably see from the slide, Peace and Justice, because often men and women choose to resolve their disputes through force. And you can see on the slide the soldiers there mounted on horses with spears and swords. That's how people often have resolved their disputes. But in the top part of the slide, you can see a different way to resolve disputes. It's three people, perhaps one judge listening to two advocates, perhaps three decision makers. And because they're resolving a dispute, listening to arguments, adjudicating based on reason and logic and evidence, one no longer needs the soldiers, and that's why the two men on horseback are riding out of the picture, riding away, and that leaves in the center of that slide, that picture, which is, as I said, on the mural of the International Court of Justice's main courtroom. That leaves peace, and you can tell it's peace because she's holding an olive branch, a universal symbol of peace, and she's also carrying a young child, a god, actually, Cronus, the god of wealth, because, as we all know, with peace comes wealth. And that mural hanging in the ICJ's main courtroom tells a powerful story about, in a sense, why we're here and what arbitration is about. But it connects a little more specifically, actually, to where we are here today. Because although that mural is titled Peace and Justice and hangs in the International Court of Justice's main courtroom, it wasn't always called that. Actually, before the ICJ took up residence, and before it, the Permanent Court of International Justice took up residence in the Peace Palace, that was the courtroom of the Permanent Court of Arbitration. And that mural had a different name. It was called Arbitration and Peace. And in a sense, that is what arbitration is about and what we're going to speak about in the moments I have with you. Because arbitration doesn't, contrary to what some say, exist autonomously or independently. It exists in collaboration with, in necessary reliance upon, national courts and national legislatures. And that's why that mural, once peace and arbitration, now peace and justice, speaks so well about our being here in this venue, the Delhi High Court, to talk about our beloved subject, international arbitration. What I'm going to do, having introduced this slide, or part of it, is talk about the past, 4,800 years of it, and the present, international arbitration today, and the future. That's the right-hand panel on this slide, the future both here in India and elsewhere. We sometimes think of international arbitration as something recent, perhaps something the British introduced, perhaps something that came with the New York Convention in 1958, but that's not true. These two pictures that you can see are the first known examples of arbitration. On the left is a fragment of something called the Stele of the Vultures. It was in Mesopotamia in around 2600 BC. It marked the border between two states, Lagash and Umma, a border which had been fought over and then drawn by a neighboring king of Kish. And this stele marked where he, as arbitrator, chosen by those two warring states to demarcate their border, decided to place the boundary, ending the war between those two states. The first known example of state-to-state arbitration, 4,800 years ago. Next to it, showing how arbitration has been used in every culture, every era, every part of the world. A cuneiform tablet that is, in a sense, the first known arbitral award. An arbitral award between Kili and Tupanaya, who I'm told had a dispute about water rights. And that cuneiform tablet, rendered by an arbitrator chosen by those two parties to resolve their dispute, awarded Kili 7 silver shekels and an ox, ending their dispute peaceably. You'll now be quite relieved to know that we've jumped 2,000 or so years into the future, from 2600 BC, to the ancient Greeks, who, both in state-to-state matters, but also ordinary commercial matters and others, resolved their disputes in the same way that Kili and Tupanaya did, by arbitration, by a decision maker chosen by them, the disputants. On the left, you can see an excerpt from Thucydides that has the treaty between Athens and Sparta from around 300 BC. That treaty had in it, in addition to peace agreements ending bitter war between those two states, an arbitration clause providing that should future disputes arise, they would be resolved by arbitrators chosen by Athens and Sparta, the disputants. Another early example of state-to-state arbitration. And on the right, an excerpt from an ancient Greek play by Menander, also around 300 BC. The play was called, fittingly enough for today's purposes, The Arbitration. And just to show that arbitration can be used to resolve all manner of disputes, the arbitration involved a domestic quarrel between husband and wife with accusations of infidelity. Arbitration was, I believe, used to resolve that, as well as ordinary commercial disputes between the ancient Greeks. And we can jump forward now another 1,000+ years to 1516, and the treaty that you can see on the slide in front of us, a treaty between King Francis I of France and the Swiss Confederation. The treaty brought peace between those two warring countries and agreed to resolve future disputes by arbitrators, two chosen by each of the two parties, with the fifth decisive voice chosen by those four, what we would call co-arbitrators, a proud home, a proud man in the language of the time, or in our vocabulary, a proud woman. We sometimes think of arbitration, notwithstanding what we've just seen, as a bit of a European thing historically. That's not true. Arbitration has been used in every part of the world, not just the Middle East, as we've seen, but also here in India, where the Panchayats, and also before that in the Ramayana, with Rama acting as arbitrator between the monkey brothers, has been used to resolve all manner of local and other disputes. And the same was true, again, in the Middle East, both in the Islamic culture, the Prophet Muhammad being recorded in the Quran as having resolved disputes, not just between Muslims, not just between Muslim tribes, but also between Muslim and Jewish communities. And still in the Middle East, the Jewish communities used arbitration, the bed den, when Roman courts were regarded rightly by them as inhospitable. And they chose instead to resolve disputes through something that the Talmud calls zabla, meaning in Hebrew an acronym for each chooses one, the method of arbitration that we've already seen in a couple of the slides. Each of the disputing parties chooses one or a number of arbitrators who together can resolve the party's dispute. And classically, the European medieval trade fairs, where arbitration was a central part of commerce, which reawakened after the Dark Ages. And this quote, which I'll come back to later, I think could have been written almost yesterday, albeit with somewhat different vocabulary. Let's look at it together. It described arbitration as the second mean, or rather ordinary course, to end the questions and controversies arising between merchants, and is by way of arbitrament, when both parties do make choice of honest women to end their causes, which is voluntary and in their own power, and therefore called arbitrium, or free will. Hence, the name arbitrator is derived. And the quote continues, I won't take us through it in the interest of time, to emphasize the impartiality of these arbitrators and also their wisdom in their knowledge of merchants' customs and the expedition by which they could resolve disputes. Those mechanisms, the arbitration, the arbitrium that Gerard Malines described in that quote that we just saw from the 16th century, that mechanism was critical to the flow of commerce in that era, the Middle Ages. Moving across the Atlantic to the New World, this is the first known example of arbitration in what became the United States. It was recorded in a judicial decision from the 1680, where the parties had agreed that 2 arbitrators would be appointed to decide the parties' dispute. And in the case that those 2 co-arbitrators couldn't agree, they would choose a 3rd person as umpire to make a final end thereof. And on this slide, again, I won't take us through it entirely. We can see some of the reasons which the Gerard Malines quote we looked at a few moments ago also emphasized. This is an excerpt from that very well-known publication, the New York Weekly Postboy in 1751. And the Postboy had in it a letter from somebody to the editor, which described how if a disputant didn't accept his counterparty's offer to arbitrate, then they would see one another 7 years hence in court and have incurred the significant legal fees that were entailed in those 7 years. The story that I have painted thus far, around 4,600 years of history compressed somewhat, has been one of a progressive ascension, in a sense, of arbitration being used in every corner of the world for every type of dispute, from domestic relations to state border disputes to merchant disputes, used by every culture and every religion. That's not the entire story, though. There was, as you can see on this slide, a New York decision from the 1950s, what the court, I think, rightly called the dark chapter, one of the dark chapters in legal history, which involved the treatment by U.S. courts of arbitration clauses. A good example of that treatment, that dark chapter, came from one of the leading U.S. international law scholars, Joseph Story. He wrote a famous commentary on conflicts of laws, but he also wrote this decision in Toby versus the County of Bristol, which reflects this dark chapter. He said, now, we all know that arbitrators at the common law possess no authority whatsoever, even to administer an oath or to compel the attendance of witnesses. They cannot compel the production of documents and papers and books of account, or insist upon a discovery of facts from the parties under oath. They are not ordinarily well enough acquainted with the principles of law or equity to administer either effectually in complicated cases. And hence, it has often been said that the judgment of arbitrators is but rusticum judicium. Ought then a court of equity to compel a resort to such a tribunal, by which, however honest and intelligent, it can in no case be clear that the real legal or equitable rights of the parties can be fully ascertained or perfectly protected. Joseph Story was renowned for his learning. But what he held in this case, Toby versus County of Bristol, like other American courts in the 19th century, was that arbitration clauses, yes, were valid. They were binding contracts, but that they were not enforceable by specific performance, and therefore if a party breached its promise to arbitrate, it wouldn't be referred to arbitration, it wouldn't be required to arbitrate. Rather, the wronged party, the party who wished to arbitrate but was unable to do so, its remedy would be in money damages. And what were those money damages? Joseph Story and American courts held that they were none, because a party who was forced to litigate instead of arbitrate was getting something better than just rough justice, rusticum judicium. And thus, for a century or so in the United States, but as we'll see also elsewhere, arbitration agreements, although formally valid, were in fact practically unenforceable. The same thing, somewhat ironically, occurred in France, where, although the United States and France differ on many things, on this they agreed. This was the Napoleonic Code, which in Article 1006 provided that arbitration agreements would be void, unenforceable, null, unless they specified with precision the object of the dispute, as well as the names of the arbitrators. Commercial businessmen not wishing to do that often included in France, as elsewhere, arbitration clauses in their contracts referring to future disputes, disputes which hadn't yet arisen and thus couldn't be described, and where the parties, not knowing what the dispute was, hadn't yet named arbitrators. In this case, ironically, handed down by the Cour de Cassation, the French Supreme Court, in the same year as Joseph Story's decision in Toby versus County of Bristol, the French Supreme Court held that Article 1006 that we just looked at rendered unenforceable, rendered invalid as well, arbitration agreements as applied to future disputes. And thus, the French courts, like the American courts, concluded that arbitration agreements were invalid. That brings us to the present. The decisions of US courts, French courts, courts in other jurisdictions as well, were ultimately overturned decisively in a series of international treaties as well as domestic legislation. This is the Geneva Protocol from the 1920s, where European as well as other countries agreed that international arbitration agreements, including agreements to refer future disputes to arbitration, would be valid and binding, and that the remedy for breach of such agreements would be a referral of the parties to arbitration, overturning effectively both the French Cour de Cassation's decision in Prunier versus Allianz and Joseph Story's doctrine, which we looked at. The Geneva Protocol was joined 4 years later by the Geneva Convention, which did for arbitration awards what the protocol did for arbitration agreements. It made those awards valid and enforceable in all the contracting parties to the convention, subject only to limited exceptions. And these two instruments, the Geneva Protocol and the Geneva Convention, were brought together in a revolutionary new instrument, the New York Convention, which you can see on the slide before us. It's very short, just a few pages. Some arbitration practitioners might, in their submissions, learn from that brevity. But what it did was critically make international arbitration agreements in Article 2 valid and enforceable, with the parties to be referred to arbitration in the case they tried to litigate instead of to arbitrate, while Articles 3, 4, and 5 did the same thing for arbitral awards, made them valid and enforceable all around the world, subject only to specified and limited exceptions. At first, the convention had few ratifying parties. It was not particularly popular. But in time, that changed, and changed fundamentally, as you can see from the slide in front of us. Today, the convention has more than 170 contracting parties. It is, in a very real sense, the global constitutional charter for international commercial arbitration. It has made international arbitration agreements and awards subject to recognition and enforcement with only limited exceptions in virtually every country in the world. Other treaties did similar things in regional contexts. And in the context of investor-state arbitration, the ICSID Convention, with only a few exceptions, became equally a global constitutional charter for investment arbitration, making investment arbitration agreements and awards subject to recognition and enforcement all around the world. That convention, the ICSID convention, became particularly important in the context of investment arbitration with the rise of bilateral investment treaties. You can see an example of the first one of these from the 1950s between the Federal Republic of Germany and Pakistan. What these bilateral investment treaties did, with that 1950s bit being succeeded by some 2,600 other bilateral investment treaties, was provide for the arbitration of investment disputes, a so-called standing offer to arbitrate by host states. And both the New York Convention and the ICSID Convention stood not just as international instruments, but were implemented on a national level. The UNCITRAL model law on international commercial arbitration, adopted in more than 160 jurisdictions around the world, including here in India, implemented faithfully the New York Convention, giving effect again to international arbitration agreements and awards. National courts did the same. You can see a good example. In the interest of time, I'm not going to take us through it. But courts faithfully interpreted both the UNCITRAL model law, but also national arbitration legislation, which, although not adopting the model law, followed its main principles, again, giving effect to providing judicial and legislative support to the international arbitral process. On the private side, because in a very real sense, international arbitration is a public-private partnership, an enterprise that involves both the state and private parties. Arbitral institutions were established, often by business organizations, and you can see a number here on the current slide, to administer in a professional sense international arbitrations. The caseloads of these grew exponentially, as you can see from the statistics on the slide. Arbitration, international arbitration, came to be used in the last decades for every sort of dispute: energy, mining, intellectual property, and the like. It was used by some of the world's largest companies and also by ordinary merchants, ordinary ma-and-pa stores. Arbitration came to be used for all manner of disputes, which historically it was not used to resolve. This is the Court of Arbitration for Sport in Switzerland, where, as again you can see from the caseloads, arbitration grew exponentially. Indeed, in a very real sense, we couldn't have the Olympics in the way that we do without a neutral, independent, and highly expeditious tribunal to resolve sports disputes. Intellectual property disputes, once non-arbitrable in many jurisdictions, became subject to arbitration, and WIPO, the World Intellectual Property Organization, established solely to administer those types of intellectual property disputes. And while with investment arbitration, which we've touched on already, ICSID's caseload grew dramatically from some 2 cases a year to in excess of 50 cases per year, with a caseload approaching 850 at this point. You can hardly open the front pages of the business section without seeing reports about international arbitration being used to resolve disputes. But again, there were dark chapters in the present as well as in the past. This is the so-called Osgood Declaration. Law professors, the fount of all evil, some would say, describing how investment arbitration was pernicious, how it interfered with state regulatory authority, how it wasn't really expeditious, how it wasn't particularly transparent. Those criticisms of the arbitral process, which although directed at investment arbitration, could equally be directed at commercial arbitration, found ready, fertile ground in various parts of the world. Hugo Chavez, as you saw on the slide before, declared that Venezuela would not honor arbitral awards, notwithstanding having agreed to arbitrate. Vladimir Putin in Russia and the Russian Federation's parliament adopted legislation that very significantly curtailed the ability of parties to use international arbitration in so-called corporate disputes. And if we think of this as confined to just some parts of the world, a man who's attracted some attention here recently announced in both his first term and his subsequent term that international arbitration was not something he wished to use either in investment or, one suspects, commercial contexts. The North American Free Trade Agreement was renegotiated, drastically limiting the use of investor-state arbitration within North America. And for its part, the European Court of Justice, in a series of decisions, significantly cut back on the use of investment arbitration in so-called intra-EU bilateral investment treaties. And as I mentioned a moment ago, this was not something confined to investment arbitration. Here, Lord Thomas described the failings of commercial arbitration, and in particular, the risk that they would deprive the courts of the common law courts in England of the opportunity to develop the law. And so, in a sense, we had the same dark chapters that we saw in earlier eras existing in the present, which therefore brings us, in my remaining moments, to the future. What does the future hold? Does it hold the bright promise that we've seen for 4,800 years? Or is it a dark chapter? One might hesitate in answering that question given the last months. One might hesitate about the role of the rule of law and adjudication as opposed to force. But I'd prefer to look to the past and look to enduring values. And I think this decision by a Canadian Court of Appeal captures what I still believe the future will hold. Arbitration, the court said, is a fundamental right of citizens and an expression of their contractual freedom. It should not be considered as an infringement upon the monopoly of state justice. Rather, arbitration should be perceived as a means of alternative dispute resolution that, depending on the circumstances, achieves certain goals pursued by the parties: speed, decision by peers, cost efficiency, etc. I want to look at both parts of that quote because they're both important. The first part I'd like to look at is actually the last sentence, which refers to what I would call the pragmatic values of arbitration. Arbitration, I would say, is characterized by the 6 E's. It's more efficient, more expeditious, more expert, more even-handed, more enforceable, and today more electronic than the alternatives. And that's why businesses choose it. We know that it's more expeditious because arbitral institutions like the Singapore International Arbitration Center, like the Delhi International Arbitration Center, have adopted so-called expedited procedure rules that allow smaller value to disputes to be resolved extremely quickly, 3 months, 6 months, depending on the institution. And international arbitration also promises greater expertise. This is a quote from the Court of Cassacion's former president. And what he said was rather different than what we saw in Prunier versus Allianz. He said, what you do, we don't have to do, a reference to the ability of arbitration to relieve crowded, congested court dockets. But also he said, in many fields, you are more professional than we are. And that isn't in any way a criticism of judges. But instead, it's a recognition that arbitration, because arbitrators are appointed after a dispute arises, will necessarily be chosen for their specific expertise in that field. And the Indian Supreme Court said much the same thing as you can see on the current slide in their recent judgment in Cox and Kings. We must also recognize, with respect to even-handedness, that although not here in India and many jurisdictions around the world, as Transparency International and others have reported, judicial corruption is a very real threat, as is the lack of judicial independence. No wonder then that parties wish to resolve their disputes by neutral, objective international arbitration. And finally, as I mentioned, the 5th E, enforceability. By virtue of the New York Convention, by virtue of the UNCITRAL model law, international arbitration agreements and awards enjoy an enforceability premium as compared to national court judgments and forum selection agreements. And for all those pragmatic reasons, businesses choose, and I would say in the future will continue to choose, international arbitration to resolve their disputes. And because of the importance of arbitration to cross-border trade and investment, I believe governments, countries will continue to support the international arbitral process. But my concluding comment is actually goes beyond that in a sense. And it's the first part of what the Quebec Court of Appeal said. It said arbitration is a fundamental right of citizens and an expression of their contractual freedom. It should not be considered as an infringement upon the monopoly of state justice. In a very real sense, I think that captures why arbitration is so important to us and to the rule of law. In free democratic societies like India, like other countries, individuals like us, you and me, are given the freedom to choose who we marry, choose who we do business with and how we do business with them, choose who we worship with, choose where we live. That freedom is essential. It's an essential part of the rule of law. Just as any free society, any democratic society allows us as individuals to choose who we make relationships with and how we make them, it also allows us to choose how we will mend them when inevitably problems arise, whether in a marriage, in a contract, in a community. And that's what arbitration is. Think back to what Gerard Malign said on this slide. He emphasized how arbitration was the exercise of the parties' free will. Note that not all in the dark chapters of the past agreed with that vision of how people, individuals like you and me, should resolve our disputes. This is an excerpt from the Reich's directives from the National Socialists in the 1930s. It addressed specifically, at the same time that the Nazis purged the judiciary, the use of arbitration by state-owned entities. It forbid the use of arbitration because, in the words of Nazi apologists, it threatened the state's monopoly on justice. The Nazis didn't want individuals to resolve their disputes, mend their relationships in a way that they would choose. It wanted rather to control them. That dark chapter ended. This is, thankfully, an excerpt from, in 1963, the German Federal Labor Court, which said the opposite. It emphasized, relying on the German Constitution, the post-war German Constitution, the fundamental right to freedom of contract, the right of people to agree to arbitrate, to choose how to mend their disputes, relying, as you can see, on a provision of the Constitution that guaranteed personal autonomy. The same thing happened in France. You'll recall the Napoleonic Code, which limited arbitration. That was supplanted, though, by subsequent decisions of the French Court of Cassation. And it's something that has been recognized here as well in India, the Indian Supreme Court emphasizing that party autonomy is the brooding and guiding spirit of autonomy. And I'd like to leave you then with that quote and that thought as well. What will the future bring? Will it bring dark chapters or will it bring continued freedom? I still believe the rule of law and continued freedom lies ahead of us. Thank you for your attention.
Thank you, Mr. Bourne, for that insightful reflection on where arbitration has been and where it must go. It was a treat not just for arbitration practitioners, but also history enthusiasts in the audience. From the global perspective, we now turn to India's own vision for arbitration, a vision guided by leadership at the highest levels of government. It is now time for the presidential address by Shri Arjun Ram Meghwal ji, the Honorable Minister of State for Law and Justice, where he holds an independent charge. The Honorable Minister also holds charge as the Minister of State for Parliamentary Affairs and Minister of State for Culture in the Government of India. A seasoned parliamentarian, he has represented the Bikaner constituency of Rajasthan in the Lok Sabha for several years. Before entering politics, the Honorable Minister served as an officer of the Indian Administrative Service, where he earned a reputation of integrity and efficiency. In his political journey, he has played a pivotal role in legislative business, policy formation, and reforms that strengthen democratic institutions. Beyond his administrative and legislative contributions, he is also known for his deep commitment to public service, social justice, and cultural heritage. His work reflects both an administrative discipline and a parliamentarian's vision. The Honorable Minister has been a driving force in India's legal reforms and a steadfast advocate for building institutions that embody integrity and credibility. His efforts to position India as a global hub of arbitration have already begun to bear fruit, and his leadership inspires confidence in India's arbitral journey. It is my honor to now invite the Honorable Minister to deliver the presidential address.
मैं 5-10 मिनट में ही मेरी बात पूरी करूंगा। खाना है ना आज? भोजन है या नहीं है? हाँ, तो भोजन के बीच में आपको थोड़ा ज़्यादा पॉइंट वाइज कुछ बात करने की कोशिश करूंगा। देखिए, एक तो प्रोग्राम तो बहुत अच्छा हमें लगा। ये अभी हमने संगीत सुना तो मुदगल साहब का जो आपको जो भजन गाया होगा, आपके किसी की समझ में आया कि नहीं आया? आया होगा ना? संगीत तो अच्छा था, उनके लिए जोरदार ताली बजा दो आप पहले। ये हमारा जो दिल्ली आर्बिट्रेशन वीकेंड था, एक प्रोग्राम, उसकी एक क्लोजिंग सेरेमनी है। और इस अवसर पर उपस्थित हमारे ऑनरेबल जस्टिस सूर्य कांत जी, जज सुप्रीम कोर्ट ऑफ इंडिया, हमारे DK उपाध्याय साहब, चीफ जस्टिस दिल्ली हाई कोर्ट, और जस्टिस सुब्रमण्यम प्रसाद जी, जो बड़ी चिंतित हो रहे थे कि मैं आऊँगा कि नहीं आऊँगा, जज दिल्ली हाई कोर्ट, और ये आप चेयरमैन हैं ऑर्गेनाइजिंग कमेटी के। थैंक यू सर। अभी आपने सुना, इसलिए सारी चीज़ें आपके समझ में तो आ गई होगी, गैरी बॉन्ड साहब को, इसलिए मैं ज़्यादा समय आपका नहीं लेके सीधा टॉपिक पे आता हूँ। ये सबको ही पता है कि हमारी ये पुरानी अवधारणा है पंच परमेश्वर वाली। हमारी लॉ सेक्रेटरी भी यहाँ बैठी है, अंशु जी, आप तो सबने नोट किया होगा न चीज़ें, और कई दिन चला होगा ये कार्यक्रम तो। और जो अच्छी बेस्ट प्रैक्टिसेज हैं उनको शायद हम जहाँ हमें लगा कि ये बेस्ट प्रैक्टिसेज हैं उनको अपने को अडॉप्ट करना भी चाहिए। पिंकी जी भी बैठे हैं, ऋषिकेश राय साहब कह रहे थे मैं तो पूरे सारे प्रोग्राम सुने मैंने, तो ऐसे हमारे श्रोता भी बहुत शानदार हैं। देखिए सर, मैं जहाँ तक समझ पा रहा हूँ, हमें सेक्शन 34 को कहीं रिविजिट करना चाहिए, मुझे ऐसा लगता है। अब आप लोगों को इतने दिन चिंतन करने के बाद लगा, आपको लगा या नहीं लगा? मुझे तो लगता है कि सेक्शन 34 को लग रहा है कि नहीं लग रहा है? तो इसमें कोई मंथन निकला हो तो हमें आप देंगे तो मेरा काम आसान हो जाएगा। निकला होगा कोई मंथन, चिंतन किया होगा, कोई रीजन आपके समझ में आया होगा। बाकी ये अब सब जानते हैं कि ADR के बिना अब काम चलने वाला नहीं है। हम कई जगह जाके भी आए हैं, लंदन भी इस काम के लिए गए, बहरीन भी गए, सिंगापुर भी गए, दुबई भी गए। पिंकी जी अपन आप साथ ही थे। और ये चीज़ें जो अपन जानते हैं कि ADR बहुत आवश्यक है। केसेस पेंडिंग रहते हैं, ज़्यादा पेंडिंग हो जाते हैं, लंबे समय तक पेंडिंग होते हैं, तो अल्टरनेट डिस्प्यूट रिजोल्यूशन मैकेनिज्म होना ही चाहिए, इसमें कोई दो राय है ही नहीं। अब इसमें क्या हमें देखना चाहिए, इस बारे में चिंतन करना चाहिए। एक विषय जो गवर्नमेंट साइड से कई बार विषय उठता है, वो मैं समझता हूँ आपके मन में भी होगा कि हमने कुछ लोग कहते हैं कि अभी तक आपने द मीडिएशन एक्ट 2023 पास किया, लेकिन मीडिएशन काउंसिल ऑफ इंडिया नहीं बनाया। ये आपके मन में भी है क्या? है? तो हम इस दिशा में बहुत तेजी से आगे बढ़ रहे हैं। जल्दी इस पे आपको इसमें खुशखबरी सुनने को मिलेगी। काफी तेजी से चल रहा है मैम। ये बड़ा एक इंटरवेंशन था। बाकी तो आप जानते ही हैं कि आर्बिट्रेशन एंड कंसिलिएशन एक्ट 1996 ये हमारा पिलर है, और उसके बाद कॉमर्शियल एक्ट 2015 ये भी बहुत अच्छा इंटरवेंशन हुआ, बहुत सक्सेसफुल काम कर रहा है। कई जगह हमने देखा है कि इसने बहुत अच्छा काम किया। अब इसमें प्री इंस्टीट्यूशंस मीडिएशन एंड सेटलमेंट वाला विषय एक काफ़ी इसने काम आसान भी किया है। इंडिया इंटरनेशनल आर्बिट्रेशन सेंटर एक्ट 2019 बना, उस दिशा में अभी जब हमने समीक्षा की तो इसमें कुछ और करने की जरूरत हमें लगता है। और मैं दो तीन चीज़ें और कह करके मेरी बात को समाप्त करूंगा कि हमने एक विजन लिया है कि विकसित भारत 2047। इकोनॉमी में हम 4th नंबर पे पहुंच गए और 3rd नंबर पे जल्दी पहुंचेंगे, ऐसी संभावना है। उसमें टिके रहना और आगे ग्रो करते रहना, इसमें मुझे लगता है कि ये जो कॉमर्शियल डिस्प्यूट है उनका सेटलमेंट अगर जल्दी होता है, समय पे होता है, और जो प्रॉपर्टी बेकार हो जाती है उसका वापस इन्वेस्टमेंट होता है या और कोई री इन्वेस्ट करता है, तो हमारा ट्रेड भी बढ़ेगा और हमारी इंडस्ट्री भी ग्रो करेगी और हमारा जो एंटरप्रेन्योरशिप की स्किल है उसमें भी हम तेजी लाएंगे। तो मैं मानता हूं कि हमारी जो इकोनॉमी की साइज है वो हम 3 नंबर तो जाएंगे ही जाएंगे, लेकिन आगे भी बढ़ सकते हैं, क्योंकि हमारे पास बहुत ऐसी संभावनाएं हैं। जब आपने देखा होगा कोई ऐसा आपदा आती है तो उसको हम अवसर में बदल देते हैं। अभी अभी आपने देखा होगा कि ये टैरिफ का विषय आ गया, ये विषय आ गया, रणनीति चेंज हुई, चीजें आपको बदलती हुई नजर आ रही है कि नहीं आ रही है? आ रही है ना। तो इसलिए इस दिशा में हमें बढ़ना है कि जो हमारी इकोनॉमी की साइज है उसको हम तेजी से आगे बढ़ाना है। रिफॉर्म हमें करना ही चाहिए। एक विषय ट्रिब्यूनल के रिफॉर्म का भी आता रहता है, कई बार आता है, तो इस दिशा में भी हमें चिंतन करना चाहिए कि ट्रिब्यूनल के रिफॉर्म्स का विषय भी हमें टेकअप करना चाहिए। तभी जाकर के हम जो विजन हमारा है, विजन फॉर द फ्यूचर, विकसित भारत 2047, इसको हम पूरा कर पाएंगे। और इसके लिए एडीआर का जो माध्यम है वो निश्चित रूप से आगे बढ़ेगा। आप सभी जजेज इसमें जुड़े हुए हैं, लीगल फ्रेटर्निटी के एडवोकेट इसमें जुड़े हुए हैं और हाई कोर्ट के माननीय जजेज भी बैठे हैं, जो इसमें एक्सपर्ट हैं वो भी सब बैठे हैं। आप हमें चिंतन मनन मंथन करके ऐसा अमृत निकाल के दीजिए कि इसमें ये अमेंडमेंट कर दीजिए, इसमें ऐसा आगे बढ़िए, तो निश्चित रूप से आपकी बात को मैं, जो भी उचित हमारा प्लेटफॉर्म होगा, चाहे जीओएम हो, चाहे कैबिनेट की बैठकें हो, चाहे प्रधानमंत्री जी से मिलने का समय रहता हो उस समय की बात हो, आपकी बात को उचित प्लेटफॉर्म पे निश्चित रूप से मैं रखूंगा। और यही मुझे लगता है कि इस वीकेंड की सफलता होनी चाहिए। इसलिए मैं पुनः आपके बीच में ज़्यादा समय नहीं लूंगा, बाकी चीज़ें आपके काफ़ी समझ में आ भी गई है। बहुत बहुत आभार आपका, धन्यवाद।
Thank you, Honorable Minister, for your inspiring words and thought-provoking insights. Your address leaves us with a lot of hope and much to reflect on. From the executive vision, we now turn to the judiciary's perspective, which is a pillar that safeguards independence and integrity in every arbitral process. We are deeply honored by the presence of our chief guest, Honorable Mr. Justice Surya Kant, Judge of the Honorable Supreme Court of India. Justice Surya Kant is a jurist of great distinction, known for his clarity of reasoning, unwavering commitment to justice, and his influential contributions to the Indian jurisprudence. He began his career as a judge of the Punjab and Haryana High Court, later serving as its acting Chief Justice. He went on to serve as the Chief Justice of the Himachal Pradesh High Court before being elevated to the Supreme Court in 2019. His judgments span a wide spectrum of constitutional, civil, criminal, and administrative law, reflecting both depth of legal scholarship and sensitivity to social realities. Today, he will share his reflections on safeguarding arbitral independence and integrity, a judicial perspective. May I now invite Honorable Justice Surya Kant to deliver the valedictory address.
Shri Arjun Meghwal ji, Honorable Minister of State, Ministry of Law and Justice, Government of India. Justice D.K. Upadhyay, Honorable Chief Justice, Delhi High Court. My former colleague, Justice Rishikesh Roy. Justice Subramaniam Prasad, Judge Delhi High Court and Chairperson of the Organising Committee of Delhi Arbitration Week. Distinguished judges of the Delhi High Court and various other high courts who have graced this occasion. Former judges, Additional Solicitor General of India and other senior law officers of the Government of India. Senior advocates, Mr. Gary Bourne, Secretary Law, Government of India. Learned distinguished arbitrators who are present here and who have come across the border, members of the legal fraternity, judicial officers, academicians, esteemed guests, ladies and gentlemen. Valedictory is a formal conclusion of any event, and therefore we have to formally close it. But thanks to Mr. Gary Bourne, he has navigated us so deeply into the world of arbitration law, and all of us are very, like obedient students, we have been able to catch up so many new ideas that he really shared with us. I will also, like Honorable Law Minister, try to wind up at the earliest, assuring you that you will get the lunch on time. It has been a gratifying experience to be here at the Delhi Arbitration Week before such a distinguished gathering. Over the past few days, you have all contributed towards stimulating discussions on a wide variety of themes reflecting on India's bilateral investment treaty regime, exploring the integration of cutting-edge technology and artificial intelligence, and engaging with evolving doctrinal debates and practical questions of arbitral practices. As I said and hinted in the beginning, standing as the last speaker after so many luminaries have shared their wisdom is both a privilege and a challenge. My reflection today turned to a subject that lies at the heart of arbitration's credibility. I therefore wish to share my views very briefly on the independence and integrity viewed through the distinctive lens of judiciary. I am reminded of a beautiful statement saying, "Justice is the virtue which ensures that each person receives their due." This statement embodies the constant desire to render to every individual what is rightfully theirs. Justice, after all, forms the very basis of the state and remains the surest bond that holds together all human commerce. Though rooted in the timeless philosophies of Plato or Aristotle, when they first reflected on the meaning of justice, the words which I have just quoted continue to resonate for more in contemporary times, even in the modern arbitral sphere. This is because arbitration, which was once a niche mechanism, has today become the backbone of commercial dispute resolution. Although arbitration promises efficiency, expertise, and finality, its legitimacy rests upon, in my humble opinion, on two essential pillars, namely independence and integrity. While independence ensures freedom from influence, integrity assures fairness, transparency, and the confidence of the parties. Without these pillars, arbitration is reduced to a hollow ritual, and it is here that the judiciary assumes its quiet but vital role. Internationally, the UNCITRAL model law establishes impartiality, independence, and disclosure as the cornerstones of arbitration. India, in adopting and adapting this framework, has woven these safeguards in the Arbitration and Conciliation Act of 1996. As most of us in this room are well aware, and indeed as several deliberations this week have highlighted, Section 12 of our Act imposes a duty of disclosure on arbitrators where circumstances may cast doubt on their independence. Section 13 provides the mechanism to challenge such appointments. In addition to this statutory scheme, the 2015 amendments to the Act marked a significant step forward in codifying standards of neutrality. The introduction of the fifth schedule with the 34 categories of potential conflicts provides a detailed framework for identifying relationships that may give rise to justifiable doubts about impartiality. The seventh schedule goes further still, rendering individuals with certain conflicts outright ineligible to serve as arbitrators, unless, of course, the parties expressly waive that disqualification. The architecture is so clear, but the real question lies in how courts interpret and enforce these safeguards. Indian courts, to their credit, have not been content with mere applying these statutory provisions. Instead, they have gone the extra mile by enriching and deepening their meaning. For example, the Supreme Court affirmed that the independence and impartiality of the arbitrator are hallmarks of any arbitration proceedings, and that even the perception of bias is sufficient to erode confidence in the arbitral process. Over time, the Supreme Court has continued to raise the bar through decisive and apposite rulings, holding that ineligible arbitrators would not only be disqualified from acting by themselves, but would also be disqualified from nominating another arbitrator, or that an interested party could not unilaterally appoint the arbitrator. Beyond these questions of arbitrator neutrality, Indian courts have also emphasized on strengthening other fundamental features of arbitration, and most notably, the principle of party autonomy, which I believe was widely discussed during these deliberations in the Delhi Arbitration Week. Party autonomy remains the backbone of the arbitral process in India, designed to give parties the widest possible freedom to shape procedures that reflect their needs and commercial realities. Courts in India, guided by Section 5 of the Act, have also been painfully conscious of the principle of minimal intervention, which Mr. Garibon was also highlighting. Of course, minimal does not mean absent. That's why the Supreme Court made it clear that while arbitral autonomy must be respected, the judiciary cannot abdicate its supervisory role where natural justice is at risk. The principle is thus straightforward. Namely, arbitrators undoubtedly enjoy wide autonomy and the court should respect it. But when fairness and impartiality are imperiled, judicial oversight becomes indispensable. Even at the post-award stage, courts assume their role only as guardians of credibility. Section 34, whereunder domestic awards may be set aside due to bias, corruption, or fundamental procedural unfairness, are well-established grounds. Similarly, even Section 48 enables the courts to cast clouds on foreign awards if they offend the public policy. Yet, here too, the judiciary has emphasized restraint and cautioned that the public policy exception must remain narrowly construed, lest it becomes a cloak for interventionism. This calibrated approach reflects not only an evolving maturity within our jurisprudence, but also India's aspiration to align with the global consensus on arbitration, which is minimal judicial intervention anchored by a commitment to independence and credibility. In fact, when we turn to comparative jurisprudence, it becomes clear that most leading arbitral jurisdictions have pursued the very same objective that India's jurisprudence has steadily embraced. In spite of this, even as our jurisprudence has matured, contemporary challenges remain. The first of which, to my mind, is the delay. Arbitration was originally conceived as a swift alternative to litigation. It is now, however, a victim of protracted timelines and excessive adjournments, often frustrating that very promise. If speed is the soul of arbitration, delay threatens to cripple it entirely. Secondly, there is the issue of quality and consistency in arbitral awards. With India aspiring to become a preferred global seat, the expectation is not merely that awards will survive judicial scrutiny, but that they must reflect a standard of reasoning and fairness that commands respect globally. And finally, the question of enforcement confronts most of the jurisdictions. While the judiciary has been cautious in its use of the public policy exception, there remains the temptation, especially in high-stake disputes, for the losing parties to seek expensive judicial review. When we consider these issues and challenges, we must understand that these are not insurmountable obstacles, but reminders of the discipline required to safeguard arbitral integrity. If we were to look at the issue of delay, the solution lies not only in stricter adjudicatory timetables, but also in adopting institutional practices such as model procedural rules that parties would have to adhere to. Case management conferences and tighter control of adjournments, all novel solutions that were highlighted during this week's deliberations, are the most effective tools. Such mechanisms have the dual advantage of respecting party autonomy while streamlining the proceedings. Similarly, when we turn to the challenge of neutrality or even enforcement, the solution lies in a deeper internationalization of disclosure obligations, so that impartiality is not treated as mere statutory compliance, but embraced as a professional instinct. These are the areas where arbitral institutions and indeed the legal fraternity at large must play a decisive role in building capacity and fostering consistency. Without their proactive engagement, the arbitral process cannot truly improve. As the saying goes, one swallow does not make a summer, and much in the same way, even if the judiciary takes strides towards a pro-arbitration stance and champions minimal intervention, such efforts will seem futile unless other stakeholders too accept accountability and responsibility in their actions. It is vital for arbitrators and the legal fraternity to pause and reflect on what arbitration truly stands for and the objective it is meant to achieve. Too often, we approach it through the lens of conventional litigation, where every stage becomes an opportunity for challenge and where delay is treated almost as a strategy. Legal practitioners, therefore, must resist that instinct, and arbitrators too must guard against extending timelines, multiplying procedural hurdles, or postponing awards without compelling cause. Arbitration is designed to be efficient, fair, and final, but when it begins to mimic the worst excesses of litigation, it risks losing its very purpose. In this sense, I would like to traverse the path of optimism and think that the very challenges we face point us to the road ahead. not towards more intervention, but towards more discipline, not towards more rules, but towards stronger institutions and deep trust, so that justice is not just done, but truly seemed to have been done. As I draw these reflections to a close, I am reminded that gatherings such as this are not merely occasions for debate, but milestones in our journey to strengthen arbitration in India and beyond. Before I take your leave, allow me to extend my heartfelt congratulations to the Organizing Committee of the Delhi Arbitration Week for yet another remarkable edition. Year after year, this gathering stands tall, not merely as a forum to deliberate on the nuances of arbitration, but as a space to connect with vibrant minds and engage with fresh perspectives. This year has been no exception. The depth of discussions and the quality of participation have been truly outstanding, and I feel deeply privileged to have been part of it. Thank you very much.
Thank you so much, sir, for those profound and timely insights on the role of judiciary in strengthening arbitral independence and ecosystem. To formally conclude this session, it is my pleasure to now invite Honorable Mr. Justice Subramaniam Prasad, Judge, Delhi High Court, and the Chairperson of the Organizing Committee of the Delhi Arbitration Weekend to deliver the vote of thanks and to acknowledge the contributions of our esteemed guests and partners. Please join me in extending a warm welcome to Justice Prasad.
Honorable Justice Surya Kant, Judge, Supreme Court of India, Honorable the Law Minister Arjun Meghwal ji, Honorable Justice Devendra Kumar Upadhyaya, Chief Justice, Delhi High Court, Justice Vibha Kru, in absentia now, Chief Justice of the High Court of Karnataka, Justice Rishikesh Roy, former Judge of the Supreme Court, my brother and sister judges of the Delhi High Court, judges from all other high courts who come across of India, former judges of this court and other high courts, a law secretary, Mr. Chetan Sharma, the ASG, our esteemed keynote speaker, Mr. Gary Bond, senior advocates, members of the bar, distinguished guests, ladies and gentlemen. It's my privilege on behalf of the Organization Committee to deliver the vote of thanks at the conclusion of what has been a truly remarkable edition of the Delhi Arbitration Weekend. This is the third edition of DAW. Year after year, DAW has gained immense popularity. In 2023, 9 international institutions participated in DAW. This year, it's gone up to 16. The popularity of any international arbitration conference also depends on the external events. What started as 6 in 2023 increased to 15 in 2024, and this year we've had 22 external events. Over the course of this year's events, we have witnessed a rare convergence of ideas, experience, and jurisdictions. We've discussed the past, present, and future of arbitration, questioned long-held assumptions, and in good legal fashion, agreed to disagree with civility and precision. And we have a long list of people to thank for this. India stands at a pivotal juncture of its arbitration journey. Over the past decade, the country has witnessed significant reforms, institutional strengthening, and a growing trust among global stakeholders in its arbitration framework. This increased confidence stems not only from the legislative and infrastructure developments, but also from a sustained commitment to aligning domestic practices with internationally recognized standards. The Delhi Arbitration Weekend 2025 serves as a powerful reaffirmation of this transformative progress, highlighting India's readiness and determination to embrace and implement global best practices while addressing its unique socio-legal context. As India continues to navigate the complexities of a connected world, such gatherings play a vital role in strengthening the arbitration framework, promoting trust, and advancing rule of law, ensuring that India's arbitration landscape remains dynamic, credible, and future-ready. First and foremost, we express our deep gratitude to our Patron-in-Chief, Honorable Mr. Justice B.R. Gavai, Chief Justice of India, for his steadfast support of this initiative and his invaluable leadership in taking this endeavor successful. His vision continues to inspire confidence in India's journey as a global arbitration hub. Our patron and chief guest today, Honorable Justice Surya Kant, sir, we are deeply grateful for your guidance, and your presence here is a strong reminder that judiciary continues to champion arbitration reform in India. I extend my heartfelt gratitude to Honorable Mr. Justice Devendra Kumar Upadhyay, our Chief Justice, who's been the strongest pillar of support. Sir, you're a true leader, and we have only followed the path illuminated by you. To our Law Minister, Shri Arjun Meghwal, we extend our heartfelt appreciation to you for taking the time to join us once again. Your address offered valuable insight into India's policy vision and arbitration. Sir, करीब 30 सेशंस हुए हैं, काफ़ी मंत्रणा हुई है, काफ़ी प्रॉब्लम्स के ऊपर विचार व्यक्त किए गए हैं, और कुछ समाधान हमने सोचा है जो आपके सामने प्रस्तुत करेंगे, और आशा करते हैं कि आप इसको आगे बढ़ाएंगे. Your address offered valuable insight into India's policy vision for arbitration, and we are grateful for your efforts in promoting a robust arbitration framework for dispute resolution in the country. To the Honorable Stephen Kegler, the Chief Justice of the High Court of Australia, so your presence has elevated the stature of this gathering, and your thoughtful reflections have added depth to our shared discourse on arbitration. We sincerely hope this is the beginning of a long continued association. To Mr. Gary Bond, our keynote speaker in this closing session, thank you once again for reminding us as to why your voice remains one of the most respected in the field of international arbitration. Your address today combined clarity, scholarship, and practical insight, and we are grateful for your continued generosity in sharing your time and expertise with us. I would like to express my sincere gratitude to my esteemed brother judges, Justice Narula, Justice Datta, and Justice Karya, along with Shashank Garg, Senior Advocate, all of whom serve with me on the Organizing Committee. Your unwavering support and collaborative efforts have been instrumental in shaping this event. It's been an honor to work alongside you. I would be failing in my duty if I don't mention and thank Justice Bhakru, Honorable Chief Justice of the Karnataka High Court, and the erstwhile Chairman of the Arbitration Committee, who sowed the seeds of this conference before his elevation as the Chief Justice of Karnataka High Court. At this juncture, special thanks to Justice Rekha Palli. She was the backbone of Dorr 2's first edition and second edition, and she gave the SOP, and we just followed that. Our thanks to the esteemed members of the Arbitration Committee as well. This event would not be possible without you, and DISC has benefited immensely from your continued support. To our speakers who brought clarity to complex issues and did so with admirable restraint on time, thank you. Your contribution has been intellectually rigorous and thought-provoking, and we have no doubt that some of your comments will quietly resurface in the next round of arbitral submissions. To our delegates across the globe, thank you for your presence and for demonstrating that arbitration continues to be, at its core, a collaborative endeavor, even when we argue passionately along the way. The DISC has grown leaps and bounds over the years, from being the first of its kind court-annexed arbitration center to cementing its position as a hub for international arbitration. The center stands on the strong shoulders of judicial officers in its secretariat, led by Dr. Sumit Parsethi, the coordinator of DISC, his motivated team comprising of Ms. Sadhika Jain, Ms. Neha Gupta Singh, Joint Registrar, Ms. Udita Jain Garg, Ms. Manu Shri, and Mr. Milan Goel, additional coordinators. This program would not have been a success without their tireless work and done by you all. I thank the members of the Executive Committee, the Program Committee, the working committee, volunteers, and everyone else working behind the scene. From logistics to the last-minute adjustments, your work ensured that the only disputes we discussed were the ones on the agenda, and none of this would have been possible without you. Not only has the DISC team worked day and night, sacrificing their weekends and holidays for Dorr, but they've ensured that DISC continues to take one stride after another towards progress. I sincerely thank them for their efforts. Due to paucity of time, I may not mention each one of you, but the organizing committee is grateful to the wholehearted support in ensuring that the entire event has been conducted without a single glitch. Special thanks to the compares and the session coordinators who acted as perfect sutradhars in every session. I thank the Registrar General, Registrar Vigilance, and the entire staff of the High Court. Organizing this event without their invaluable unflinching support would have been a nightmare. We are also grateful to our academic partners, sponsors, and institutional supporters who have stood with us not just in name, but in genuine partnership. Your support has helped transform vision to reality. As we close this edition of the Delhi Arbitration Weekend, we carry forward more than just contact lists and conference kits. We carry forward conversations, collaborations, and a shared commitment to excellence in arbitration. Thank you once again, and we look forward to welcoming you back in the next edition. Jai Hind.
Thank you, sir, for such a warm address and your words of appreciation. On behalf of everyone here, I would like to express our sincere gratitude to Honorable Justice Subramaniam Prasad, not just for so graciously delivering the vote of thanks, but also for being a constant source of guidance and support for putting this event together. His thoughtful inputs, steady encouragement, and quiet leadership behind the scenes have played a vital role in making the third edition of the Delhi Arbitration Weekend such a resounding success. Thank you, sir. Now I request the Honorable Chief Justice of the Delhi High Court, Honorable Mr. Justice Devendra Kumar Upadhyay, to felicitate Honorable Mr. Justice Surya Kant and Honorable Law Minister by presenting a shawl and Prabhavali as a token of our respect and appreciation. Can we have a huge round of applause, please? I request Honorable Mr. Justice Subramaniam Prasad, Chairperson of the Organizing Committee for DAW, to felicitate Mr. Gary Bond and Honorable Mr. Justice Devendra Upadhyay by presenting them with a shawl and Prabhavali. A Prabhavali is a traditional ornamental arc crafted in intricate brasswork, symbolizing India's rich heritage of craftsmanship and cultural expression. Set against a backdrop of hand-woven Indian textile, it reflects the country's enduring traditions of artistry and design. We hope it serves as a meaningful reminder of your time at the Delhi Arbitration Weekend 2025 and the timeless elegance of the Indian craftsmanship. Ladies and gentlemen, before we draw curtains on today's event, may I request everyone to please stand up for the national anthem.
Punjab, Sindh,
From Mr. Bond's global reflections to the Honorable Law Minister's vision for India's arbitral future, to Justice Surya Kant's call for independence and integrity, this has been more than a dialogue. It has been a reaffirmation of arbitration's role as a cornerstone of justice. Delhi Arbitration Weekend is not merely an event, it is a collective movement to build stronger institutions, to elevate standards of practice, and to secure India's rightful place on the global arbitral map. I, Anusura, on behalf of the entire organizing committee, thank you all for your presence, your engagement, and your commitment. Until we meet again, may the conversation begin here continue to resonate in our courtrooms, our boardrooms, and every arbitral tribunal where justice seeks its voice. Thank you, ladies and gentlemen. I welcome you all to now please join us for lunch on the 6th floor. Thank you so much.